My name's Jim Walsh. I'm a lawyer from Austin, Texas. I'm very glad to be here. I was here 2 years ago, and then not last year because it didn't happen. And this is the first airplane trip I have taken since, before all this. So it was pretty exciting yesterday. Airplanes are still working like they used to, so that's good. All right, so our topic today is about behavior plans. And I'm going to kind of lead into that by starting out with a little background on what do we mean by free appropriate public education, because I think that all fits in together. So that's how we're going to talk about it. I'm happy to take questions, and I'll pause periodically and see if you guys have some questions. We have plenty of time. We have an hour and a half, and so that's plenty of time to cover the material. So just a little bit more about me. I've been doing this a long time. I've been doing school law for over 40 years. And our law firm in Texas, this is pretty much all we do. All we do is represent school districts. And so we work with people like you all the time. And I do a lot of presentations like this, so I look forward to it. So anyway, that's enough about that. So SCOTUS, do y'all know that term? You need to use this term when you're talking to your lawyer friends. It'll impress them. You'll instantly establish street cred if you refer to SCOTUS. They'll say, oh, this is a person who is a force to be reckoned with, okay? So of course it stands for Supreme Court of the United States. That's what SCOTUS is. And for those of you who like to kind of keep up with it, the best website I know of is called SCOTUS Blog. I think it's scotusblog.com, and it's got lots of information about all the cases that are pending or might be heard or have been heard by the Supreme Court. So that's a good place to kind of plow around a little bit and see what you find interesting. So I want to talk about the Endrew case. Now this is now 4 years ago. It was 2017 when the Supreme Court issued a decision in the Endrew case, and it was about what does this term free appropriate public education really mean? Now we've had that word since 1975, free appropriate public education. We know what free means, we know what public education means. The big fight has always been what's appropriate. That's a very subjective term. So how do we make sense of it? Now they first defined it in 1982. And you all probably know about that case. That's the case of Amy Rowley. And Amy was a very different student than Endrew. Amy was a first grader. She was very bright. She was in special ed because of a hearing impairment. She's deaf. Her placement was fully mainstream. She was expected to perform at grade level with all the other first graders, and she did. In fact, the evidence in the case was that she was one of the better students in the class, got along well with teachers and students. Everything's going well for Amy, but her parents wanted her to have a sign language interpreter, and the cheapskates in New York would not let her have a sign language interpreter. So this case works its way all the way to the Supreme Court, and it's the first opportunity for the Supreme Court to tell us what they think appropriate means in free appropriate public education. And so they told us that Amy didn't need the sign language interpreter, and they based that on the fact that she was doing quite well without it. And that's a good starting point when a parent asks for something new. How's a student doing without it? Because if the student's doing well without it, that would indicate they don't need it. It might be beneficial. The sign language interpreter would have helped Amy, no doubt, but she was doing very well without it. So the important thing for our purposes is the court said in that case that we're only talking today about kids like Amy, kids that are mainstreamed, kids that are expected to achieve at grade level. That's what this case is about. So they told us the school is not required to offer the best possible educational program. We are a public school. It's not feasible that we can meet every conceivable desire. We can't provide everything that would be beneficial. So we have the term need. And that's really the only recognition in the law that you guys do have limited budgets. Sometimes the law makes you act like you don't. But you do, and it's a zero-sum game. You spend more on one program, you have less to spend somewhere else. You spend more on one student, you have less to spend on everybody else. It's a zero-sum game. So the only way the law recognizes that is with the word need. So parents get for their children what they need, and they have the burden of proving that they need something before they can require the school to do it. So the school had to offer an IEP that was reasonably calculated to confer some educational benefit. How do you like that for a standard? Some educational benefit, you know? You ask somebody to fix you a bowl of ice cream, and they fix you a bowl of ice cream that is clearly one scoop too small. You know, I wanted some ice cream. I gave you some ice cream. It's not what I wanted, you know? So some is a very mushy term. That's what they said. You have to confer some educational benefit. So how much is some? So here's what the court said. They said, now again, we're only talking about kids like Amy Rowley. And they said it's pretty obvious that Amy is receiving a benefit from her education. How do we know that? She's in a first grade mainstream classroom, and she is mastering the curriculum better than most of the kids in the class. She's going to be promoted to second grade. And she earns promotion to second grade because she's done everything that a first grader is expected to do. So that's how we know. And they said for those kids, if they are moving from grade to grade with their peers, then it looks to us like they are already receiving a free appropriate public education. So Amy doesn't need the sign language interpreter. Now the parents brought in some expert witnesses that testified that with a sign language interpreter, she'd pick up more of what's happening in the classroom. And that's kind of obvious. Nobody would dispute that. And the court said, yeah, well, she's doing pretty well with what she can pick up, so that's it. And the court left it to another day, what some benefit would mean for all those other students that you serve, those students who are not mainstreamed, who are not achieving at grade level. It took 35 years before that came back up. So that's Endrew. And Endrew, you know, I listened to the oral argument in Endrew's case, and the lawyer that represented Endrew he laid it out pretty plainly there. He said he's not on grade level. He probably never will be. He had a combination. He was on the autism spectrum. He had intellectual disability as well, as I recall. So he's a lower functioning student. And he was not placed in the mainstream for the whole day. I don't remember what his placement was, but here's what the Supreme Court came up with. They said, okay, for kids like Endrew, you have to offer an IEP that's reasonably calculated to enable the student to make progress appropriate in light of the child's circumstances. Well, now that's just crystal clear, isn't it? I mean, that's, you know, and this is a unanimous Supreme Court decision. And it's written by Justice Roberts. And I will tell you, I think he's one of the best writers on the court. Indiana product, by the way. You all know that, right? So he, and I have a lot of respect for Justice Roberts. That's the best he could come up with. And I think it's the best anybody could come up with, given what this law says, appropriate education. So they said it has to be an IEP that's calculated to enable the student to make progress, but it has to be progress that's appropriate for this particular student, because this student is not Amy Rowley. And we're not going to measure this student on the basis of grade level standards. That would be inappropriately ambitious. And so they said, so anyway, it's pretty mushy, pretty subjective, but I always want us to go back to the basics in special education law. We individualize, and we individualize based on data that's specific to the particular student. Here's a couple of other tidbits from this case. The court said developing an IEP is a fact-intensive exercise. So we really have to have a good grasp on who this student is, strengths, weaknesses, etc. Informed not only by the expertise of school officials, but also by input from the child's parents and guardians. You know, one hallmark of special education law is that we solicit and value parental input. Now, you know, schools always say that in their handbooks about all parents, and I think they mean it, but in special ed it has legal consequences. You know, you just heard Julie talking about cases where parents allege they were denied meaningful participation, or things were predetermined. That doesn't happen in general ed. So in special ed, we really have to solicit and value parental input. And so the court points that out. Now look at this, an IEP is not a form document. Oh, really? Do y'all have forms for your IEPs? I bet you do. I bet you do. I bet you have forms, I bet you have software, and you have to, you know, you have to. In an ideal world, I think an IEP would be a blank sheet of paper. And the people that know the student and care about the student would start from scratch and write the plan, but we can't do that. But the Supreme Court said, and this is a direct quote, it's not a form document. So your forms are helpful, but they shouldn't completely dictate the process that we're going through. We have to be willing to break away from the form. Court said it's only constructed after careful consideration of the child's present levels of achievement. Where are we right now? The disability and the potential for growth. Again, looking at the specific student. For kids like Amy, for students that are served in the mainstream and taught at grade level, the system itself monitors the child. You all have standardized testing for kids every year? All right. And you have grades, of course, and you have kids that are promoted from one grade to the next, or high school kids that get credit for a course. That's the system monitoring the students, and the system monitors by itself. Court said it happens through regular exams, grades, yearly advancement. What about Endrew? Court said if progressing smoothly through the regular curriculum is not a reasonable prospect, then the IEP need not aim for grade level advancement. Now I will tell you, most of the cases that have come out since Endrew have been, that have used the standard in the Endrew case, they've mostly been lower functioning students. And they've been mostly cases where the parents thought that the IEP was too low. And for the most part, the courts have said, no, progress appropriate in light of the child's circumstances. And so, it is okay to write an IEP that is not expecting the student to achieve at grade level. In fact, for some kids, an IEP that calls for the student to achieve at grade level would be inappropriate because it's setting the student up for failure. So that's what they said. And here's some of the language that I think we should be incorporating into our IEP meetings. You all don't need to talk much now you call them case conference committees, right? CCCs? Okay, I got to get used to that. Of course, we call them ARD meetings in Texas, so it's admission, review, and dismissal. Some people think anguish, remorse, and denial, but it's actually admission, review, and dismissal. So we call them ARD meetings, which is very helpful because when Julie was talking about the tough ones where you get beat, parents that curse at you and yell at you, and so we call that a hard ARD. And, I like that. I think that's good and that's helpful. So, but you don't have that, do you? CCC. I don't know that any other state uses CCC. I've run into, some states call it the Committee for Special Education, the CSE, but you're the CCC, so I'll try to remember that. Anyway, I think this language should be brought into your case conference committee meetings. I think this is good language. The IEP must be appropriately ambitious, and it should have goals that are challenging, again, for this particular student. That tells me that if every kid in your school district achieves 100% of the goals on their IEPs, you probably weren't appropriately ambitious. Because if you're appropriately ambitious with all students, some of them probably not going to make it, all right? So I think that's good language that we should use. They also said this. They said courts should defer to you guys. You all are the leading experts, not only on education, but on this particular student. You're the leading experts. And so courts should defer to you. Judges are not supposed to be second guessing your judgment calls. But they put a caution around that. They said deference is based on the application of expertise and the exercise of judgment by school authorities. So they're going to defer to you if you're worthy of being deferred to. And that's going to be based upon, have you really used your expertise? Have you used your judgment? And they put this in here. This is, there's three quotes from this Supreme Court decision that I think are particularly important. Appropriately ambitious, challenging objectives, and then this one, cogent and responsive explanations. A reviewing court may fairly expect those authorities, that's you all, to be able to offer a cogent and responsive explanation for your decisions. That's the way we've always done it, is not a cogent and responsive explanation. So we have to use our expertise and so on to be able to explain what we've done. So how do you proceed? I think with an IEP, you start one question, just a starter question. Is this student more like Amy or is this student more like Endrew? That's kind of a divide of the students, and it's just a starter, but I think it's a fairly good place to start. In either case, we want to design an IEP that's appropriately ambitious. Here's that quote from the court: "The goals may differ, but every child should have the chance to meet challenging objectives." So you know, I really think that the IEP process has gotten way more cumbersome and complicated than it was supposed to be. How long are your IEP forms now? How many pages? Anybody know?
It depends on the kid.
It depends, yeah. Is everybody using the same form statewide? Is there a statewide form? Well, how long's the form? Just if we just looked at the form.
It's actually not a form, it's a process.
It's a process, okay. Okay. Well, give me an idea. The typical student in your school district, if we printed out their IEP, how many pages are we talking about?
8 to 10.
15?
15 for a leap year one.
Okay, all right. Okay, so they're long. they can be pretty long. And, you know, I think that it would help if we would think about this like we think about other goal-setting processes. Because that's what this is. That's what this is. This, you know, the CCC meeting is a parent-teacher conference on steroids. That's all it is. And it's also, I always think it's worthy to emphasize that that CCC conference that you have is, it's got a lot of legal ramifications, but the main thing that's going on is communication. The parent's going to walk away from that meeting with 2 impressions. How professional are these people? And how much do they care about my child having a good experience in school? That's the main thing we should be focusing on every time we get together. The paperwork is important. Dotting your I's and crossing your T's is always important. I'm a lawyer, of course I'm going to emphasize that. But the main thing that's going on is communication. And what we're doing is we're just setting a goal. We're saying, here's where we think the student is, present levels of performance. Here's where we think we can be a year from now, assuming that we provide the services that are needed and that the student does the student's work. We think this is what we can accomplish in a year. And then we establish some criteria. How are we going to know whether we've made it or not? I call that the measuring stick. So it's a goal-setting process. So, you know, it's no different than the goals that most of us have had at some point in our lives: lose weight, save money, pay off debt. Most of us have had those goals. You know, if you think, the thing that's easy about those goals is they all involve numbers. You know, if I want to lose 15 pounds, if I want to save $10,000, if I want to reduce that student loan debt by X amount within a year, numbers. Numbers make goal setting a lot easier. Not easy to achieve, but easy to at least establish the goal. Here's where I am, here's where I hope to be, here's how I think I'm going to accomplish it. That's what we're doing when we're writing an IEP. Here's where the student is, here's where we think the student can be. Here are the services that we need to provide in order for the student to achieve that. And here's the measuring stick. So that's all we're doing. Now we're going to tie this into behavior plans. I know that's what we're here to talk about. But I think, and I looked at your Indiana regulations this morning, by the way. Your regulations specifically say that a BIP is a part of the IEP. And it's developed by the case conference committee. That's not the case in every state. But in Indiana, it's crystal clear that a BIP is no different conceptually than your IEP for reading or mathematics or anything else. It's a part of the IEP. It's developed by the case conference committee. So make sure you have sufficient evaluation data to make your decisions. When you have consensus on that in your meeting, then you're ready to talk about present levels. When you have consensus on that, then you're ready to establish measurable goals. And that's when I would ask the Endrew F question. When somebody puts down, are you guys projecting things on the wall so everybody can see it when you're having your meeting? I think that's a good practice. So when you put the goal for whatever, language arts, math, behavior, life skills, when you put the goal on the wall, that's a good time to stop and ask the Endrew F question. Is that an appropriately ambitious goal for this student? Is that a challenging objective? I would ask that question. See next slide. By the way, this is how I build excitement when I'm doing a PowerPoint presentation, because I don't even have clip art here. You know, I don't have video, no sound, no movie clips. Sorry, but you're excited right now. You know, I'm looking around the room and some of you are on the edge of your seats. What's on the next slide? So this is just a technique I want to share with you. See next slide. Leader of the meeting should eyeball each member of the case conference committee and ask, do you think these are appropriately ambitious goals for this student? Are we aiming at challenging objectives? I'd look at the parent, I'd look at the teachers, ask them all. You think we think we got this right? Then you have consensus on that. Now you're ready to talk about the services that are going to be needed to achieve the goals. Now this is the sequence in which your meetings should occur. Present levels, goals, then the services. How do you know what you're going to have to do to lose 20 pounds until you establish it's 20 pounds I'm after, not 5? What are the services that, well, how am I going to do that? How am I going to save $10,000? So same thing here. And then we talk about placement. You know, if you're talking about placement of the student in the first 10 meetings of your meeting, I think you're off base. We talk about placement after we have decided what services we're going to provide. You have to do it that way in order to fulfill the LRE requirement. You know, once we know what services, oh, this is a student who needs speech therapy, this is a student who needs counseling, this is a student who needs resource time for language arts. Now we can talk about what's the least restrictive environment in which we can provide that level of services. So it's important that you do that in the right sequence. Then we want to make sure to be implemented. I didn't hear all of Julie's talk, but I got into the part where she was talking about the failure to implement. And you know, I've been calling those second generation 504 cases. You know, if you look at litigation over Section 504, the early cases were just about access to education, access to extracurricular activities, getting in the door, removing barriers that would keep students with disabilities out. We're now on the second generation of cases. The second generation of cases is all about failure to implement. And so we have to stay on top of this, make sure it's implemented. If they're not being implemented, it's the principal that needs to take corrective action. You know, I've been invited to some school districts to try to put the fear of the law in the teachers. I got into Julie's talk. She was just talking about Mr. Withers from West Virginia. Do y'all remember her telling about that guy? That poor man. We lawyers have been beating up on that guy for decades now because he's the only one we know that personally got sued and lost over the failure to implement the IEP. So we're always using him to put the fear of the law in people. But you know, what I tell school people about this is if you have a widespread problem on your campus, if it's not just one teacher, but if there's kind of a widespread problem of teachers not taking a 504 plan seriously, coaches not understanding that 504 applies to extracurricular activities, teachers not providing the accommodations that we've included in the IEP, if that's a widespread problem, it's the principal that needs to address that. And the principal doesn't need to do, you know, the principal just needs to select one teacher to issue a firm but kind corrective memo, and then you let the teachers lounge do the work for you from there, all right? But you know, I've been invited to talk to the teachers, and you know, I do my dog and pony show. I don't think it does much good. They know I'm going to be gone the next day. The principal has to hold people accountable for this type of thing. Okay, and then we monitor for progress, and we have to be honest. And I'm going to show you a case in a little while where the district had a real problem with that. Okay, so let's talk about behavior. That's enough background on all this. We're here to talk about behavioral plans. So I will tell you, I grew up, I didn't go to public school, I went to Catholic school for 13 years, and the behavior plan was something else. It was, now, you know, those of you who have only, if you didn't experience it and you've only seen the movies, you think, oh, he got whacked on the knuckles with a ruler. No, no, no. It was a lot worse than that. It was psychological, mostly. Sister Mary Holywater would skillfully combine communism and purgatory. Communism, she had us convinced we were not going to live to see our high school graduation. The communists were going to get us. You know, they were godless atheists. They hated Americans, but they had a particular dislike for little Catholic boys and girls. And so our school was targeted. You know, we were told, And then that's combined with purgatory. Now, a lot of you may not be familiar with that. It's sort of a celestial after-school detention program. It's an afterlife detention program, all right? And so we were frightened and fearful of purgatory. And so that's how it worked. So I've looked back at my class pictures to see if I'm remembering accurately. Did we really have 40 kids in 3rd grade with no teacher's aid? Yes, we did. 40 frightened children. Therefore, 40 compliant children. So that worked, you know, but you can't do that. You can't do that. So let's talk a little bit about what you guys can do. So here's my starting point, and this is why I wanted to lead off with a little review of fundamentals of IEP development. Because you guys, this is in your forms, right? Your forms, I know, have a question in it. And the question is, does the student have behaviors that impede the learning of the student or others? And you check yes, and do you have yes and no boxes on that? All right. If you check no, okay, great. You check yes, you have to address it. Now, you don't necessarily have to write a formal behavior plan, but whatever method you have for recording the things that the team talked about should reflect that we then discussed it. What can we do about this? So that's kind of the starting point for developing a behavior plan. Does the student have behaviors that impede the learning of the student or others? And if the answer is yes, we should have a discussion of how we're going to address that. Now, a couple things about that question. Notice that the question is not limited to disability-related behaviors. I think a lot of people assume that we're only talking about behaviors that are a manifestation of disability. I don't see any basis for that. The question is, does the student have behaviors that impede the learning of the student or others, period? And if the answer is yes, then it has to be addressed, okay? So you could have behaviors that have absolutely nothing to do with the student's disability. They still need to be addressed if they're impeding learning, okay? So I think that's important. Identifying a behavior in response to this question does not mean that the behavior is a manifestation of disability. I have principals that are fearful of saying, yes, this is a behavior we need to address, because they think that's going to tie their hands if there's a disciplinary incident later in the year. If we say that the behavior is if we say the behavior impedes learning, are we also saying that the behavior is a manifestation of disability? Well, no. But I think your whatever forms you're using, you might want to spell that out. You might want to make that clear. Just put it in there. The identification of a behavior as impeding learning does not mean that the behavior is a manifestation of disability. It just means that it's a behavior that impedes learning, okay? Do y'all have any foul-mouthed kids here in Indiana? By any chance? No? Okay. Well, just in case you did. Aaron here says no, we don't have any, but do you pronounce that Aaron? Okay. Just in case you did. You know, I don't know about you, but I typically think that probably has nothing to do with disability. But if it's enough of it, you know, it impedes learning. It's a behavior that needs to be addressed. I get a lot of questions about this. You know, I do a lot of training on discipline, and my next session is called the Toolbox, and that's going to be more specifically about discipline. What about behaviors like drug offenses at the school, sex in the bathroom, stuff like that? Are we supposed to write a behavior plan for things like that? Well, I don't know, but I think those are behaviors that impede learning. Why does your school prohibit possession of drugs at school? Well, because we always have, because it's illegal, because it's harmful to kids. Yeah, okay. Does it impede learning? I think it does. I think having drugs at school impedes the learning of the student who's taking the drugs or selling the drugs or trying to buy the drugs. What about a couple of students having sex in the bathroom? Maybe it's consensual. You know, maybe it's not really sexual harassment, but does that impede learning of the student or others? Well, they're learning something. But, you know, very valuable life skills perhaps, but they're not learning what's in the curriculum here in Indiana. And so that's a behavior that impedes learning. So I think we need to take that question seriously. I think you need to ask it more than once a year. These incidents that I'm talking about typically would lead to, in most school districts, they would lead to long-term disciplinary action. or serious disciplinary action. That means it's a behavior that impedes learning. And so don't we want to address that in some way? So I take that question pretty seriously, okay? So, suggestion, ask the question again if the student engages in serious misconduct. Now, there's no legal template for a BIP, at least not nationally. Do you guys have one in Indiana? Is there some sort of template that everybody's operating from, or do individual schools have a template? Some of you.
It can be incorporated in IEP.
Oh, what?
Through our IEP process, one can be formed.
Okay, so there is a piece of paper or form on the computer that's kind of our template for how we develop it. Is that what you're saying? Okay, you have that. You know your name's upside down, don't you? It's okay with me. I can handle it. Yeah, that's all right. Okay, but legally there's no legal template, and it sounds like you don't have anything specific in Indiana. You have a lot of flexibility. One of my favorite cases, it was a number of years ago now, but it was a case where a student had a behavior plan and the parent alleged that it was an inadequate behavior plan and he was not receiving an appropriate education. And one of the things the parent raised in the litigation was that your BIP fails to comply with the legal requirements for a BIP. And the court's response to that was, there are no legal requirements for what a BIP has to look like. It's impossible to write a BIP that fails to meet the legal standards because there are no legal standards, okay? And I think that's true. The law does not define BIP. It describes it, but it doesn't really define it. So you have a lot of discretion, but you always want to pay attention to the evaluation data. So I would think of a BIP as you think of an IEP. And I think the fact that Indiana specifically says that a BIP is approved by the case conference committee and is part of the IEP, that makes the case even more. Present levels, goals, services, okay? I'll tell you, one of my first experiences with a behavior plan was in a small district in Texas that had a 16-year-old student with autism, and he also had an intellectual disability, so he was a lower functioning student on the spectrum. And he was 16, he was pretty big. And when he lost control, he was scary because he could be violent. He was working in a campus that I think was entirely women. And they were pretty much afraid of him because there was nobody that could physically control the student. So that was part of what the school's dealing with. But he had a lot of inappropriate behaviors. And the mother was threatening litigation, and that's why I was involved. And they called me one time and they said, we want you to talk to the teacher. So, okay, put the teacher on the phone. So I'm on the phone with the teacher. Well, how's he doing? Not very well. Well, what's he doing? Well, there's a lot of inappropriate behaviors. Well, what are you talking about? She said, well, it's kind of sexual. I said, okay, it was just me on the phone here. What are we talking about here? She said, well, he masturbates in the classroom. And I said, mon Dieu. Because this hadn't happened in my 13 years of Catholic schooling. And so I was surprised to hear that this happened. I said, how often? Now I was anticipating the answer to that question. I thought it'd be once every 6 weeks. No. She said, well, one day last week, 47 times. I said, sacre bleu. I said, could you be a little more specific about what you're classifying as masturbation? And so she did, with some hesitancy, and I said, well, let's reclassify that. Why don't we call that touching himself? She said, okay, all right, we'll call it touching himself. I said, 47 times, yeah. She said, so what do we do? I said, we got to develop. I don't know if I used the term BIP, but at least at that time, I was a pretty young lawyer at the time, but I recognized this is a behavior that needs to be addressed. The behavior was obviously a manifestation of disability, okay? So we're not going to punish him for this. When you have behavior that is a manifestation of disability, there's two don'ts. Don't punish, don't ignore. And so that's what we want to do. We're not going to punish this. That would be like punishing him for having autism. We're not going to do that. But you can't ignore it. It's an inappropriate behavior. So she said, well, what do we do? I said, well, I don't know. Why don't you see if maybe you can teach him the concept of privacy? He doesn't have a high level of cognitive ability, but let's see if you can get him to understand the concept of privacy. And some things that you do, maybe you do that when you're alone. And she said, okay, she's writing that down. I heard the pen going across the page. And I said, and what else? I said, well, you want to get the number down. You know, present levels, 47 times. I bet we can make progress on that. Let's count, and let's see if we can, you know, get that number down to a more reasonable number before the end of the year. And she wrote that down. I heard the pen going across the page. She said, you know a lot about this. I said, well, you know, I'm your lawyer. I take all my personal life experiences and try to help you any way I can. So, you know, and I've reflected back on that, and I thought, I knew nothing about BIPs, but the first part of a BIP is the goal, and that doesn't require any expertise. That's common sense. This was an inappropriate behavior, especially in the school setting. This needs to be addressed. You know, unless he's going to become a Major League Baseball player, he can't be touching himself this often with other people around. So we're not going to ignore it. We're going to address it. So that was just the common sense. Now the hard part, that's the first part of writing a BIP, the goal. And I would maintain that anybody with common sense can tell us what the goal is. The hard part is the how-to, all right? Now how are you going to prevent this behavior or reduce this behavior or substitute something else? How are you going to do that with this particular student who has this combination of disabilities? How are you going to do that? That's why you guys need some expertise. Because for the life of me, I'd have no idea how to do that, okay? So that's what we're doing. So we think of it kind of like an IEP goal, okay? There's two parts, the goal and how to achieve it. The first part's just common sense. The second part requires a great deal of expertise. You know, I'm a little careful about telling that story, by the way. I will not tell that story to the Kiwanis Club or the Rotary or any non-school group, because there are enemies of public education that would take a story like that and twist it. Can you believe what they're teaching our kids to do in school these days? I could just hear that, you know. And, you know, but we were doing exactly the right thing by that student, you know. He must be in his 40s by now. What do you want to bet he's still on the spectrum? What do you want to bet he still has a low intellectual ability? What's the goal? The goal is for him to be able to live in the community, perhaps work. This is a behavior that needed to be addressed. So we were absolutely doing the right thing, morally, legally, ethically, but not everybody understands that. And so I don't mind telling you guys, because I'm sure you have some situations kind of like that. I've learned that it's not that unusual. Okay, more thoughts about BIPs. Doesn't define it, but it describes them. So I want to talk a little bit about the distinction between your code of conduct and your behavior plan. Because I think it's very important that we have that distinction clear. I'm going to go a little bit further here. I said I'd pause for questions. I'm going to do that. I'm going to do that very shortly here. So if you have questions, be thinking about that. But one thing I encourage people not to do is there's three things I would encourage you not to put into a BIP. Number one, short-term negative consequences like out-of-school suspension. Do your principals have the authority to order a short-term out-of-school suspension? Can principals do that in Indiana? Yes. All right. Can principals order kids to in-school suspension for a few days? Yes. Okay. Why are we putting that in a behavior plan? It's not a positive behavior intervention. You know, behavior plans are described as positive behavior intervention strategies and supports. 3 days in-school suspension is none of that. And it's not like you have to put it in a BIP to give the principal the power to do it. The principal already has the authority, okay? So I would leave that negative stuff where it belongs, which is the code of conduct, not the BIP. Second thing I would not put in a BIP is physical restraint. Now you guys have a whole lot of rules and regulations about that. I looked at them briefly this morning. And they're pretty typical for what, you know, our state has something very similar to that. But I wouldn't put that in a behavior plan. That's not a positive behavior intervention. You know, if I get a call from the assistant principal, Mr. Walsh, we had to restrain your child physically this morning, I don't count that as a positive thing, all right? It's not a positive behavior intervention. It's a response to an emergency. And that's the only time we use it, is when we have to, because somebody's going to get hurt if we don't. That's when we use restraint. So I wouldn't put that in a behavior plan. And the third thing I wouldn't put in a behavior plan is bringing in law enforcement. Now that's a controversial thing, and I understand a lot of parents don't want us to have anything to do with the police, but this is a discretionary thing that principals have the authority to do. It's not a positive behavior intervention by no means. Mr. Walsh, we had to call the police to deal with your child this morning. That's not a good phone call. So it's not a positive behavior intervention, and it's not something that we have to give authority to do. It's already authorized. So those are some things I wouldn't put. I'd leave them in the code of conduct. BIPs do not replace the code of conduct. I don't know if y'all hear this. I used to hear this sometimes. Oh, she's not subject to the code of conduct anymore. We wrote a BIP. If you hear that, correct that person. No, she's still subject to the code of conduct. All kids are subject to the code of conduct. But some kids have a BIP. So the easiest way to create legal problems for you is to put things in the BIP and then not do them. So be careful about overloading the BIP with precise instructions of how we're going to respond to certain types of student misconduct. Because, I mean, I only see it in the court cases, but in the court cases, that's, you know, we're just setting the staff up for failure. Because in the heat of the moment, they're not going to do it exactly the way it's written. So I think it's more about the positive behavior interventions, the strategies, the supports to prevent recurrence of these type of behaviors, okay? And so we want to stay on top of this with teachers and monitor for behaviors and then do something different. That's what I just said. If the BIP spells out detailed protocols for how we're going to respond to things, we're probably going to fail to do it. So focus on preventing misconduct or replacing inappropriate behaviors. So here's some language you might want to consider. This code of conduct applies to all students, but in enforcing its code, the district will comply with the state and federal regulations pertaining to students with disabilities. In other words, we know that if it's change of placement, we have to go through the case conference committee. We know that we have to do a manifestation determination. We know we have certain state laws that we have to comply with. That summarizes it. Code of conduct applies to everybody, no exceptions. But the enforcement of it, we recognize some special rules for our students with disabilities. And then if we write a BIP, I would put this into the BIP. This BIP is designed to assist your child to comply with the code of conduct. That's what it's about. It's the only tool in your toolbox that's designed to improve the student's behavior. Everything else in the toolbox that I'm going to talk about after lunch is about managing the student's behavior, okay? So I already made this point. All of these negative consequences are available, should be used rarely. And so I'll leave it at that. So there was one other, the other thing about the code of conduct, do you all use that term, code of conduct? Is that the term you use for where you have all the thou shalt nots, so to speak? The code of conduct is a useful document, but nobody reads it until the student does something that's so creative that we don't know how to classify it. So I think of it as a reactive document. We look at the code of conduct in response to some student behavior that we're not sure, how do we handle this? Best example I heard of this recently, this happened in a district a little bit outside of Austin where I live. I don't think it ended up in litigation, but it's a terrific story. Some kid apparently called a stripper and got her to show up at the middle school to entertain the assistant principal at like 9:30 in the morning. So, and the stripper turns out to be the hero of our story because she apparently was on the early morning shift and she gets this dispatch from her dispatcher, and it just gave the address, go to such and such a place, ask for Mr. Johnson. So she does, and she pulls up. And oh my God, it's a middle school. So instantly she knows, this is a prank. This is a prank. She could have just turned around and gone home, but she didn't. She comes in and she introduces herself to Mr. Johnson. She says, I'm whoever, and I'm here to entertain you. I suspect you don't want that right now. Here's my card in case you're interested in something later. And then she said, and here's the credit card that authorized this. And they traced it back to the student who came up with this brilliant idea. Does your code of conduct prohibit calling a stripper to entertain the assistant principal? I suspect not, all right? And you don't want to put it in there. Because if you do, somebody will read it and think, there's a good idea. So it's reactive. We have to figure out, that's a violation of something, isn't it? But how do we classify it? So the code of conduct is reactive and the BIP is proactive, okay? So I'm doing all the talking here. Let me pause for a second. You know, we're in a windowless room without a clock. Okay. Questions? Questions from you guys? Questions, comments? Lawyer jokes? No? Okay. All right, well, let's go on. We'll talk a little bit more. So FBAs, I call them FBAs, functional behavioral assessments. At the tail end of Julie's talk, she was talking about that Second Circuit case, the Trumbull case, that said that a functional behavioral assessment is not the type of thing that can generate an independent educational evaluation. You know, we don't have to worry about that in Texas because we just recently had a state law passed that says that if you're going to do an FBA, you will seek parental consent to do it. But talk to your school attorneys about this, but I would encourage you to treat an FBA as something for which you need consent. That's what OSEP has said, that's what most of the courts have said, that's the safer course of action. I would encourage you to treat it as something for which we need consent. Now, since it is something for which we need consent, or that I think we should anyway, let's think about that. You know, I don't know what you consider to be a functional behavioral assessment. It looks like your state regulations do have a definition of it, and they do have a description of the process. If all you're doing is reviewing data that's already been generated, looking at the discipline reports, looking at the attendance records, looking at the IEP, looking at previous behavior plans, if all you're doing is looking at documents that already exist, data that already exists, I don't think that's an FBA. I think that's a review of existing evaluation data for which you do not need parent consent. So if we need parent consent to do an FBA, I think that implies that the FBA involves doing something we haven't done before. Doing something we haven't done before on an individual basis with this student to determine what is the function of the behavior that we're concerned about. The BIP has to be supported by evaluation data, and this is usually done by an FBA. I don't think it's always mandatory. It's undefined in the law. You have flexibility, but it's wise to base your decisions on professional expertise from people who know how to do a BCB, an FBA. OSEP says you need consent, and that certainly implies that it's more than just a review of existing data. So I want to share with you a case that I think is a real good illustration of some of what we're talking about. It's a real good illustration of the failure to follow the data in your decision making. You know, we hear the term data-based decision making a lot in special ed these days. And every once in a while I bump into a court case that provides an excellent example of how not to do it. And I'm delighted when it's not from Texas, because I hate to talk about cases where schools screw up in my home state. I'm going to embarrass somebody. This is also not from Indiana, so we don't need to worry about that. Let's kick Maryland around just a little bit, okay? So this is a case from the state of Maryland, and it's involving a behavior plan decided last year, and that's where it's cited in Special Ed Connection. There's some real good lessons to learn from this one, I believe. So as a student who had a behavior plan, now the behavior plan called for, I would call that a pretty aggressive goal, a 75% decrease in the frequency of self-injurious, aggressive, and sexual self-stimulatory behaviors. How many behaviors are we going to look at? How do you read that? How many behaviors are we going to look at? Three. Those are different, right? Self-injurious is not the same as aggressive. Aggressive is not the same as sexual self-stimulation. Those are three separate things, right? That was the first mistake they made. They didn't recognize that there were three behaviors, apparently. And I understand how this can happen. The background of this is this student had a BIP for a long time that addressed self-injurious behaviors. That had historically been the behavior that the school was concerned about. That was the behavior they were looking at. Then they had a meeting and they added some things to the BIP. But apparently people didn't notice that, oh, now we have two other separate types of behavior that we want to address. And we want to have a 75% decrease. That's a strong goal. That's an ambitious goal, it seems to me. So one goal, 3 separate categories of behavior. So they end up in litigation. And in the litigation, the district produces its progress reports. And the progress reports said that the student's making good progress on this goal. All right, that sounds pretty good. In fact, this is the language they had: making sufficient progress to meet the goal with regard to every single objective. So self-injurious behaviors, on target to meet the goal. Aggressive behaviors, on target. We're headed for 75% decrease. Sexual self-stimulation, we're right on target. We're on track to meet that objective. That sounds good. But there was a problem, or we wouldn't be talking about it. All right? See next slide. All right. There are actually 2 problems. There's 3 categories of behavior. There was 0 data about how frequently the student was aggressive, and there was 0 data about sexual self-stimulation. So somehow there was a disconnect between what happened at the IEP team meeting where they added these goals and the follow-through. Whoever was responsible for tracking the goal and keeping up with the BIP didn't get it, that we've added 2 new behaviors that we want to look at. So we have no data to support our assertion that we're making good progress on 2 of these 3 categories of behavior. And the data that they did have did not show progress. In fact, this is a remarkable statistic. When I read this, I wonder, they must not have been counting things the same way. Because when they started, the present level of performance on self-injurious behaviors was that the student engaged in that type of behavior 17 times a day. That's quite a lot right there. But it escalated to 108. And I wonder, what? You wonder if they're counting the same thing, or if they've changed their definition of what self-injurious is, because that's pretty remarkable. And it sure doesn't show progress. The goal was decrease, right? We're going from 17 to 108. That is not a decrease. So that was a problem. The court said the progress code on every objective states we're making sufficient progress to meet the goal. But the accompanying data does not show progress, or on some of the objectives, it actually shows regression. All right? So that's a problem. Then there was occupational therapy. Do we have any OTs in the room? Any OTs? No? Okay. So they didn't rely on progress reports with regard to the occupational therapy. They had the live testimony of the occupational therapist, and she said the student's making good progress. Now that is what the courts will classify as a conclusion. One of the things that comes up in these cases sometimes is the distinction between a conclusion and a fact. Okay? How many think it's too warm in here? You do? See, that's a conclusion. Now if I say, do you feel too warm? And you say, yes, I do. That's a fact. You see the distinction? But to say, it is too hot, it is too cold, that is a conclusion. To say, I feel cold, I feel hot, that is a fact. The court says, when you say the student's making sufficient progress to achieve the goal, that's a conclusion. Where's the data that supports that? That's what we have to get down to. So it's not good enough to just give me the conclusion. Oh yeah, the student's doing great. How do we know? So OT testified the student was making progress on the OT goals. That's a conclusion. Court said that testimony is not supported by her own written notes. So apparently her notes told a different story than what she testified to in the case. And the court is interested in the facts, which are in the data, rather than the conclusions. I found this real interesting. The court said, the parents' lawyers filed this memorandum in support of their case, and they detailed several instances of this sort of inconsistency. And the court says, it kind of looks like the computer program has a default setting, maybe, that says we're making sufficient progress. I read that and I thought, boy, that's credible to me. I can really see how that could happen. Now, there's nothing wrong with having a computer program, and all computer programs will have a default setting, right? Nothing wrong with that, but we have to train the staff to move away from the default setting as the data dictates. And that's apparently what they didn't do here. They just went with the default setting all the time. I mean, I don't know this. This is just speculation from the court, but when I read that, I thought, boy, I can see how that happens. I could easily see how that happens. So the lessons from this case, these parents were exceptionally well represented. You know, I read a lot of litigation, just like Julie does. I can tell she reads all these cases. I do too. And you know, you can tell sometimes the quality of the lawyering. These parents were well represented because most lawyers would not have gotten down to the level of the data. Most lawyers would have looked at the progress report and said, well, you know, the school says your child's doing very well. I don't know, you know, I don't really think we can win this one. These lawyers dug beneath that, and they found the data, and they found the disconnect between the data and the conclusions. Those are good lawyers. And, you know, it's a good thing that we have lawyers like that. It's a pain in the butt sometimes, but that's what holds us accountable. That's what holds us accountable. So we don't want to let our practices get sloppy, okay? So always assume you're held to that level of accountability. What's the bigger legal problem, do you think? Reporting a lack of progress or reporting progress when we don't have any progress? What's the bigger legal problem? I think you know the answer to that question, okay? So keep your perspective on this. IDEA establishes appropriately ambitious goals for our entire society. This thing we're trying to do of serve every single child and meet their unique needs and provide them an education that's truly meaningful for them, that is an incredibly ambitious goal for us as a society. We do that regardless of the nature or the severity of the disability. We do it even though the funding has never been adequate, never will be. It's a very difficult thing you're doing. Pile on top of that COVID, and you know, I'm preaching to the choir. You guys got your hands full with what we're trying to accomplish here. You make your best efforts toward this goal. You're not just complying with legal requirements. I do like to remind people of this. We sometimes get bogged down in all the legalisms and all of that. Why do we have all this law? Because it's a moral obligation first. It was a moral obligation before it was ever a legal obligation. We got the legal requirements because the thinking was that will ensure that we fulfill our moral obligations, okay? So go forth and do good, all right? So there's my contact information. So what questions you guys have? Let's talk a little bit about BIPs and issues that are coming up in your district, or what else I can help you with. Got some time for some Q&A. Always look forward to that. Patrick, you were here last time, weren't you? No?
This presentation?
Yeah, thought so.
It was 2 years ago.
Somebody like you, yeah. Yeah, there's always a guy like you, yeah. Yeah. I mean, it's a good thing. All right. Yes, ma'am.
We are having a couple of cases that the parents are seeing behaviors at home.
Yeah.
But we are not.
We are not seeing it, okay? Yeah, real common situation. You know, it is behaviors that impede learning. It is the behaviors at the school that count. And I can understand how frustrating that is. I had a child like that. So I get it. I get it. But you know, our focus is, our responsibility is the behaviors that impede the learning of the student. And there's quite a few court cases that say that. So, you know, you'll have situations where parents are having trouble with criminal activity by their children. The police are getting involved. There's serious consequences the student may be facing. Obviously, that's very stressful to the family. It's not the school's legal responsibility unless it's spilling over into what's happening at the school. So I think we listen to that, and but we bring out our data. Well, now here's what we're seeing. You know, your child has not violated the code of conduct. Your child has not been suspended. Your child has not been subject to any disciplinary actions here because your child's behavior at the school is good, and your child's academic performance is good. Now, if that's true, then I think you can legitimately say, you know, we're not going to write a behavior plan for these things. We have our hands full with behaviors that do impede learning at the school, okay? So I think that's a hard conversation you have with parents sometimes.
And they're going to the emotional side of it, where it's internal and they're holding it in at school, and we don't see the outward.
Right.
So that's where it's been hard to prove that.
Yeah, and you know, and you have the opposite problem too. I'll bet you have some kids who are misbehaving at the school, and the parents say, well, I can't believe that because we don't have any problems at home. Well, you know, well, sometimes that's because there's no boundaries at home. There's no structure at home. And sometimes that's it. I mean, sometimes it may be something different, but our focus needs to be on the performance at the school and the behaviors that are impeding the learning at the school. So that's what we look at, all right? So, what else is up with you guys? I'm sorry?
We're seeing a huge influx of students exhibiting extreme behaviors.
Extreme behaviors.
Likely due to mental health
Uh-huh.
concerns, which
All right.
goes outside the realm of what educators have been taught.
Yeah.
So just guidance on that. I
Yeah.
know we try to include as many people on the team, but a lot of times they have, say, an emotional disability, we have a behavior plan, but it's more of the mental health component.
Right. I noticed one of the presentations here is about trauma as it affects IEP development. I think that might be a real good one for you to attend. Question, if you didn't hear it, is about kids with serious mental health issues, because we're seeing more of that. And I'm sure you are, and that's going on all over the place. You know, I will tell you, I don't think there's any bright line distinction between what we do and regardless of what's the basis for the problem. If it's a behavior that impedes learning, it's something the school needs to address. You know, it's comparable a little bit to me. In the early days of special ed law, we saw quite a few court cases about services that were medical in nature. You know, the second case that went to the Supreme Court, after Amy Rowley's case, the second case that went to the Supreme Court was involving a 3-year-old with spina bifida who needed catheterization in order to go to school. And this is the early days of special ed law. This happened in Irving, Texas. This is in my state. I wasn't involved in it, but anyway, the school district said, well, we don't do that. That's medical. We don't do that. They went to the Supreme Court, and the Supreme Court said, you will do that. Because it sounds medical, but the evidence was, you know, a trained paraprofessional could provide this service. You didn't need a doctor, you didn't need a nurse. In fact, this little girl's older brother did it for her when she was at home. So we had to expand our concept of what our responsibility is. That happened with medical type of issues in the early days, and now it's kind of a given. I think it's happening with the mental health issues now. This is the responsibility of the school to address to the best of our ability. This is why you so desperately need better funding. And you know, every state, I think, in the country, after the rash of school shootings, went through the debate, how do we address this? And the term I heard was, harden the outside, soften the inside. Harden the outside of the school, make it more difficult for the wrong people to get into the school, have some security protocols. Soften the inside. Let's address trauma. Let's address kids that have been exposed to violence. Let's address kids. But you need people to be able to do that, you know? And your typical teachers are not well trained to address that. We need social workers, we need psychologists, we need behavior specialists. But I think legally, this is something it is within our responsibility. Okay? Yes, ma'am.
I just wanted to comment on that. I'm a clinical therapist, and I think sometimes kids are just misplaced, and sometimes they need a different placement.
Mm-hmm.
And schools are trying to do something that is not within their abilities.
Do you think sometimes in order to meet these needs we have to change the placement to a more restrictive?
Yeah, because I see kids being suspended, and the problem is never really addressed.
Uh-huh.
It needs to be addressed.
Mm-hmm. Yeah.
I think it's a disservice to the student.
Well, you know, you have to have the type of placement that would meet those needs, though. You know, and that's a real challenge for a lot of schools. But yeah, disciplinary action doesn't really address these things. I don't know if y'all are. Is Indiana moving much in the direction of restorative practices? Are you? Chandler up here says yes.
Yep, our district has.
Your district is? How long have you been doing it?
It's been 2 years.
You see any positive benefits of it?
It's been hard to gauge because COVID, we saw a
Yeah.
decrease in behaviors with
Right.
being hybrid, with students being out. We were struggling right now just to find days to train teachers in it,
Uh-huh.
to find people to come and
Yeah.
find the time and the schedule to do it. But I would say the outlook is positive for it.
Yeah. I'm a big supporter of restorative practices. I think they hold a lot of promise, but it's something that you can't do it halfway. You have to commit to it, and it's a long-term commitment, and it's a lot of training, and it's so, you know, but that's something, if your district has not looked into that, I would certainly encourage you to do it, because that's a way of addressing these, what we're calling mental health issues. But I don't think we can just dismiss it and say, oh, well, that's mental health. No, if it's affecting education, then there you have it. And also, when you say mental health, I mean, that frequently involves disability, does it not? There was I'll take your question in just a second. There was a case from Minnesota where a school district disenrolled a child. If I remember this right, they disenrolled this kid 3 different times, 8th grade, 9th grade, and then again in high school, always due to lack of attendance. And they never had the student in special ed because they didn't think she needed it. And the court said she wasn't attending school because she has mental health issues. And that's an indication that maybe there's a disability that's impeding learning. And so we should have looked into that, was the message. Yes?
We have a student that's currently in the process of being evaluated to be eligible for special education. The student has missed more than half of our school days so far due to suicidal comments. The family comes and picks them up. So I'm curious, aside from us recommending the student see a therapist, get support, if the parents are, it seems to be in denial about the scenario right now, is there any other course of action we can take besides saying, please get this student help outside? Anything more we can do?
But what are we
for
doing?
parents
What are
that
we
choose
doing? What are
not
we
to?
doing to address the students' issues? Because those are I mean, you haven't completed the evaluation,
That's
right?
correct.
Yeah. So the question is, does this student qualify as having a disability? And if the student does qualify as having a disability, they're eligible for special education, which can include psychological services, can include counseling, can include social work services, can include parent training. So my question would not be, what can we ask the parents to do? Let's clean up our side of the street. Let's do everything that we can. And what the parents are going to do beyond that, you don't have much control over that. But I would say let's make a thorough look at what the school can do, because we got a wide array of related services that we are supposed to consider with kids like that are suicidal. That is not something that we can just turn over to the parents. So it's a distracting laptop you have there. I'm trying.
I like stickers.
Yeah, I'm trying to study it. So all right, good stuff.
Yeah, not all appropriate. It's not my
No,
style.
well, it's there's nothing inappropriate. Nothing that
Some
I
of
can
them
say.
are covered up.
Yeah. All right. Yes, ma'am.
So I work with InSource, by the way. So I work with the parent
Uh-huh.
who has a kindergartner, and the school is saying there's nothing wrong with the child other than being spoiled. So, but he has very abnormal behavior. He hits the teacher, he hits the students, he spits on people. So the parent is saying that there's something wrong with the child. The school is saying there's nothing wrong. So, and the kid gets sent home almost every day. So
Yeah.
the parent is upset.
So is the child in special education?
No,
Have they done an evaluation?
no.
Has the
school
parent
is-
asked for an evaluation?
I suggested that the parent ask for one, but the school keeps saying there's nothing wrong with him. other
Well,
than
they
this
can
one.
the parent just needs to ask for an evaluation, and that puts the burden on the school.
Yeah.
When you get a parent request for an evaluation in writing to make sure it's clear when we did it, when you get that request for an evaluation, the school only has 2 responses that are appropriate. One is, here's the consent form, please sign, and we'll do the evaluation. And the other response that's appropriate is a prior written notice, which would explain to the parent, no, we're not going to do the evaluation, but here's why, and here's our procedural safeguards document, and to inform the parent of how they can challenge the decision the school just made. So that's what needs to happen, is the parent needs to, it sounds like it's just been verbal so far,
Yeah, I think it has.
Yeah, so put it in writing, ask the school to do an evaluation, and that puts the burden on the school to respond in one of those 2 ways. If they refuse, if they say, no, we don't think there's any sign, and they could, it would be appropriate if the school believes there is no sign of a need for special education here, then they write a prior written notice and they spell that out. We don't see anything that indicates that there's a need for special services. Okay, then they're not going to do the evaluation. Now the ball's back in the parent's court. What are you going to do about that? You can request a hearing, you can seek mediation, you can file a complaint with the state agency. Those are the options. We have these dispute resolution mechanisms for a reason, and they're designed to assume that people will act like grown-ups and will follow the process and see how that works, okay? So good luck with that. There's always, I always caution schools about questioning parenting techniques. That's usually not a good thing for us to be doing. I used to I had, I've taken phone calls from special ed directors for decades, and it's really interesting. And they're hardworking, good people working under stress and difficult circumstances. But I listen for little things, like I hear, what's the relationship with the parents? Well, mom's in prison. The mom's in prison, and dad hasn't been around since the child was 3 years old. My attitude toward that comment, mom's in prison, kind of changed when my wife started a nonprofit organization working with women in prison. And I started to understand, just because mom's in prison doesn't mean mom doesn't want to be involved, doesn't mean that there's not still a responsibility to do something here. So anyway, y'all deal with the whole spectrum of humanity out there. You have parents that you love to work with. You have parents that are difficult to work with. You have parents that are what I call 10s on the Cleaver scale. I don't know if y'all remember the Cleaver family. Some of them don't remember it. I don't think it's even on Nick at Night anymore. But I see you older people chuckling. Ward and June Cleaver would be your ideal parents. They would volunteer at the Halloween carnival. Mrs. Cleaver would bring cupcakes to the CCC meeting. In her high heels and pearls and apron. They would be great. But you got people that are not 10s on the Cleaver scale. You have people that are -2 on the Cleaver scale. And they're hard to work with, But that's one of our responsibilities is to work with the whole spectrum of humanity that's out there, okay? So yes, ma'am?
I don't know how well this fits into our discussion, but we have a student who, he's a senior in high school, he's deaf, has an interpreter, he goes to a career center in the afternoon, but he wanted to switch from the program that he's in to the fire program.
Wants to be a firefighter?
He wants to be a firefighter. And the program isn't governed by this career center. They just have space on the property. And they said, no, you cannot.
Why?
Because he's deaf.
Because he's deaf. You can't be a firefighter if you're deaf. Is that?
Pretty much. But,
yeah.
But my thought is it's not the fire academy. There's different avenues he could go.
Yeah. Well, let me try to expand this for the benefit of everybody. How old's the student?
He's a senior.
How old?
18.
18. There you go. That's an important factor. So who's the decisive person? He is. He is, not the parents. Okay, that's one thing. So if you didn't hear all that, the question is about an 18-year-old senior who is deaf and is wanting to change his program from whatever. Criminal justice. He's interested in being a firefighter, and somebody that's responsible for that program that says, well, we're sorry, but you can't be a firefighter if you're deaf. I don't know all the ins and outs about this, but let's just talk in general. Number one, if the student's 18, it's the student that we're working with, not the parent. That doesn't mean we're ignoring the parent, but it means the decisive person at the CCC conference. I keep calling it the CCC conference. That's redundant, isn't it? It should be the CC conference, I guess, or the C conference. Anyway, the CCC. The decisive person is the student, not the parent. It sounds like the student is asking for a change in his placement. Because if his IEP calls for him to be in this career center, that's what the IEP calls for this school year, he's asking for a change. We should have a meeting to discuss it. And at the meeting, we want to gather information. We want to have somebody who's knowledgeable about this program he wants to get into. And if their position is, we don't take people who are deaf, I don't know if that's legally defensible or not. I don't know. But that would be a question I'd want to know. I'd want to talk to a lawyer, that you just categorically refusing services to students who are deaf without thinking about reasonable accommodations. I'd want to have that conversation. So that's all I would know to do is let's have a meeting. Let's bring in the relevant people. Let's see if it's possible to make this change. And if the IEP team wants to make a change, they can make a change. And if not, then it's the student's responsibility to decide, what he wants to do about that. Okay? So, hope that's helpful.
Yep, thank you.
All right. All right. What else? What else? You want to go to lunch early? We can. What time is it? 11:32. We can get the jump on the other people. All right. So I'm going to be, my afternoon session is also about student discipline, but it's what I call the toolbox, and it's a short introduction to what's an all-day training program, but it's about the full array of things that schools can do in response to inappropriate behaviors in the school. And if you do come to that, I will tell you the first tool is BIPs. So we're going to repeat a little bit of what we said here. But the other 9 tools are other things that we haven't talked about yet, okay? So that's happening at 12:45, I think it is, when we have the afternoon, okay?